Hello, and welcome to another episode of Brooklyn Law School's series on law in time of crisis. I am pleased to be joined today by Professor of Law Julian Arato, who also serves as co-director of our Dennis Block Center for International Business Law. Julian is an expert on both public and private international law, and we're very pleased to have him here today to talk about international economic law in time of crisis. So, Julian, obviously, we've had international treaties for some time. Through the late 20th and early 21st century, it seemed like there was a move toward increasing freedom of trade and openness of borders with respect to economic activity. And in the recent past, we've seen a bit of a retrenchment of localism, isolationism, protectionism, however one wants to put it, not only in American politics and government, but around the globe. Is that a function of the pandemic, or is that something that transcends this recent crisis?
It's an interesting moment for international economic law because we're sort of in the middle of a double crisis. So on the one hand, the answer is really no, right? There's been this slow-moving crisis within the field where the expectation was more multilateralism, more institutionalization of international economic law, trade law, investment law, just as you said, and beginning with the Brexit moment and really snowballing with the onset of the Trump regime, this has completely reversed course, right? Multilateralism, it seems to be crumbling at the seams. This is really, really centralized in the US and the UK and a few other countries, but there's also been threats of exit by some of the BRICS. South Africa, India are exiting bilateral investment treaties, and there's been problems at the WTO since the turn of the millennium and the failure of the Doha round. So Trump and the Brexit have been obviously the catalyst of all of that. So on the one hand, we have that crisis that's been slow rolling, but for a while there was a feeling like, well, maybe Trump will go away and maybe Brexit won't even happen, or if it does, it's not so bad. But the pandemic kind of struck with, it's a much more serious crisis on every level and a global one. And with the pandemic, it became clear that a lot of the sort of basic structures of the system that we've been depending on for a long time don't clearly work that well to grapple with this kind of problem. And so faith in the system, even by its former defenders, in the various different systems of international economic law, has really, the crumbling of that faith has accelerated. So it's there's been a slow rolling crisis, but then the sort of exogenous crisis of the pandemic coming in has really opened up our minds, opened up our eyes to some much broader failures that can't be just attributed to Trump, Boris Johnson, and a few others.
An individual crisis, of course, comes as a surprise, but the fact of having a crisis is something that repeats itself. Crises, not to say they're commonplace, but they're certainly something that recur. And in fact, somewhere in the world, there frequently is a crisis. So one would think that large multinational treaties would incorporate some sense that crises occur and perhaps some anticipation of how they will be addressed when they arise. To what extent do our treaties bake in some expectation of crisis, and how poised are they to handle one like the one we're going through?
Yeah, that's absolutely right. Crises have happened all the time, and crises can be many different kinds of things. You can have a global health crisis. You can have an isolated economic collapse. So look, it's worth saying a bit about what these treaties are supposed to do. International trade treaties at their core are about reducing tariffs, reducing discrimination of foreign goods against foreign services, and all of that. International investment treaties are about reducing local threats to foreign direct investments, to incentivize foreign direct investment, right? And so all of these treaties are, in a way that states can credibly commit to other states in order to encourage private economic operators to either trade with a country or to invest in a country, to provide services in a country. So what you're doing by signing onto this treaty, it's like an act of tying yourself to the mast, right? You say there are a bunch of things that we won't do. We won't raise tariffs. We won't discriminate against your goods in favor of our goods. We won't expropriate your property if you build a mine in our country or something like that. And there's different remedies for the different types of treaties. And, we could talk about the details more. But the overall picture is one of constraint, self-imposed constraint on the international level in order to encourage cross-border business in all of its forms. So how far is that going to go? Well, of course, states aren't delegating away their ability to manage a true crisis, right? That couldn't be, right? If you have a risk of societal collapse, right, the state has to deal with that, right? That's the main function of a state, right? So that includes health, that includes environment. And so those things are built into all of these treaties in different ways. The most important trade regime, the WTO, the General Agreement on Trade and Tariffs that preceded it, they have a structured system of exceptions for when you have a legitimate public policy to deal with public health, environment, national security, what have you, almost anything you can think of. There's an analysis that asks whether or not you can meet this exception, then it absolves the sin of breaching the treaty, right? It's justification, it's not excuse. Investment treaties are more complicated because they're really short, they don't really say it, but everyone understands states didn't delegate their ability to deal with a national security threat, right? Of course, an investment treaty doesn't prevent you from defending your country. So the problem that the pandemic has exposed is that the way these regimes structure this flexibility through this exceptions system is really problematic for a couple of reasons. The first is that by doing this through exceptions, it kind of sets the bar automatically really high for justification, because the assumption is the norm is free trade, the norm is investment, the norm is not interfering with foreigners, and only if there's a really special case, an exceptional case, do we allow the state a free pass. And that's not a formal burden of proof, but that has a great anchoring effect, and we've seen it in the cases that the anchoring effect is really strong, the norm exception problem. But the global pandemic has also shown another problem, which is that once you start to see not local, isolated, exceptional situations, but really truly extreme global events like the pandemic, you suddenly start to see a proliferation of claims to the exception for all kinds of values. And you can imagine this happening more with climate, more with public morals questions, right? I mean, all kinds of things. And as this sort of proliferates, every kind of regulatory goal you can imagine is an exception. Well, what's the norm then, right? Are we in a state of constant perennial exception? It's sort of it's a strange way of looking at the world, and one which undermines confidence in the system, right? The system is supposed to promote certain goals, but if we're always in a state of exception, what good is it? So it's not just that it limits the ability for states to regulate and to claim exceptions, but it also undermines its own purposes by sort of weakening the notion that these are normal times treaties.
To what extent should we expect litigation as a result of the pandemic or as a result of the response internationally in law to the pandemic? And what would we predict in terms of the results of that litigation?
Yeah, this is something that folks in my circles talk about a lot. And, I've personally gone back and forth on this. I mean, the first thing that happened, moment one of the pandemic, is that all of our friends at law firms or colleagues at law firms ran around to all of their clients and said, like, here are the services that we can provide. And so there are going to be a lot of measures that might implicate trade and investment treaties. Just to be clear, trade treaties, usually the state has to sue. So one state sues another state, and there are no damages or anything like that. It's really a matter of prospective regulatory penalties. So there, I don't really imagine there's going to be that much of a floodgate of suits unless a state does something really egregious. Most of the measures states are taking are, first of all, lockdowns, virus mitigation measures, things like that, and then economic recovery measures where maybe a state smuggles in some really egregious protectionism. You can imagine a state suing another state over that. But for the most part, we're all in this financial crisis together. So there will be lots of states doing lots of things which might seem to violate a trade treaty or an investment treaty, but other states won't have a problem with. Investment treaties, though, provide private individuals direct access to an international suit against a foreign state for damages, usually measured in the millions and billions of dollars, percentage points of a country's GDP. Private individuals have no incentive to exercise restraint, except maybe not wanting to pay an adverse costs award, right? Bringing these suits is expensive. If it's a frivolous suit, it's not worth it. Even then, you can settlement shop because it's so scary to face one of these suits. You sue a state like Guatemala or Mexico, and you say, look, we'll just pay us to leave, right? Pay us, we won't sue. It's tempting, although there's national pride at stake, and you can't just pay off everybody, obviously. So not a lot of trade disputes I would expect, although there will be some, but with investment disputes, you can expect, I think, that there will be a lot. Early on, there was a sort of lot of noise that there would be a lot of disputes about virus mitigation measures. And there I'm skeptical, right? I mean, lots of companies will be put out of business by lockdowns. We're seeing it here every day. Restaurants, hotels being put out of business, right? Foreign-owned hotels too. You could theoretically bring a dispute, but I think most lawyers will recognize that there's kind of global solidarity behind the idea that these lockdowns are necessary. And unless you just want to take your client's money, which you should not do, you should not be advising your client that you're going to have a lot of success bringing a suit for one of these measures that everyone's taking. What arbitral tribunal would dare to say a state, for having passed a lockdown, not discriminatory, but on everybody, owes millions of dollars to some foreign investor, but not to domestic owners of those kinds of businesses? But we can draw a distinction between that and economic recovery measures, right? And that's important because there, the sort of field is going to be much lumpier across different states. Countries are going to be doing lots of different things to get their economies back on board. And when you have difference, you can sort of open your flank to the accusation of parochialism. So the more that an investor can say, oh, look, this country's doing some weird thing and it happens to just affect me more than some national, it's discriminatory, maybe it's arbitrary, right? And those suits start to look better. And at least for settlement shopping purposes, they start to look more attractive. But I don't think it's going to be about what everyone is worried about, these virus mitigation measures. I think it's going to be about the weird, lumpy economic recovery measures. That's when the flood will really ensue. And it's a huge problem.
The one ongoing opportunity this series has presented is not only to learn from scholars about current events, but to hear about how those current events have informed the work of scholars. Are there ways in which things that are happening out in the world right now have changed or impacted your scholarship or what you plan to do in the classroom?
Yeah, so both for sure. With the scholarship, I've been involved in the reform efforts on the international investment side. My scholarship has taken that into account. It's a kind of a moving target, right? I'm not a reporter, and so my work can't follow the up to the minute thing. But there's this constant temptation to sort of make sure everything is as current as possible. And honestly, the speed of the reforms, the speed of the changes and the new proposals has had maybe the counterintuitive effect. To me, what it's kind of done is drive home the necessity of doing what I think I do best as a scholar and focus on the sort of deeper issues, the ones that I hope will stand the test of time. So it's actually driven me a little bit away from trying to do the up to the minute, blow by blow reporting on all of the recent developments, maybe in a blog post, but that's not, a 60-page paper is going to be behind the times by the time you get to page 10. By contrast with the teaching, though, it's maddening, but it's affected the teaching in a very positive way, I think. Trade law, for example, has become a total moving target. Every semester when I teach trade, I teach it once a year, usually in the spring. By the time I ramp up to teaching it again, I have to throw out half of the course that I taught the last time. When Trump was elected, it was kind of obvious that some of this was going to happen. At first, it was just a few little tariffs here or there. And so you can say, oh, the U.S. is doing tariffs again. And that's interesting, but suddenly the entire appellate body mechanism is collapsing. And I'm teaching this course based on case-based methodology, and this court doesn't exist anymore. That requires some pretty thorough reconstruction of the course, which can be done, and it's fascinating and it's fun. It's maddening because it creates a new prep every year, but I think that makes it almost more exciting for the students because it requires those of us teaching trade, not just myself, but everyone at every law school doing this, to be at the top of our game every class. You just can't repeat what you said the last time because the world is changing a mile a minute. Sometimes for the better. In trade, right now, maybe not. But then again, there are much bigger problems in the world.
Well, thank you so much, Professor Julian Arato, for helping us understand this dynamic world of international trade and international economic law. Interested viewers can go back and watch our episode on international tax with Professor Stephen Dean. Got a shout out from Professor Arato. So go back and take a look at that, and also be on the lookout for our next episode of Brooklyn Law School series on law in time of crisis.